Good evening, everybody. I'm Deepak, your host for today's evening. I hope everyone is safe at home. Today, I will walk you through what are the issues that are required to address while in terms of intellectual property rights whenever there is a merger or acquisition that takes place. So, identifying a potential target is the first step. And after the identification of potential targets, due diligence takes place. And finally, the merger and acquisition takes place. So, today I'll discuss the nitty gritties of intellectual property rights in the domain of mergers and acquisitions. So, I'll discuss the things, what are the preliminary considerations that are required, and finally the due diligence which needs to be taken care of while doing the mergers and acquisitions. So preliminary considerations include what is the nature of the buyer, what is the transaction structure, what is the nature of the business of the target, and also who knows, because the acquisition is taking place, so who knows about the IP assets of the target company. So these preliminary considerations must be taken care while doing this process. And due diligence, it's necessary to identify the IP assets. IP assets can be patents, copyrights, trademarks, or designs, or they may be semiconductor chip designs also. So due diligence, we have to take identify the assets, who owns them, how the IP was developed by the target company, whether it was third party or in-house research and development team. Also, there is a need to look for IP in the agreements that have been signed between the by the target company with various vendors, employees, and things like that. Then finally, we will take a look on the IP related disputes that have taken place. So, as I said, the preliminary considerations includes the nature of the buyer. So nature of the buyer is whether it's asset purchase, whether it's a stock purchase, a reverse merger, or a forward merger. So I'll give you an idea of what is reverse merger. Reverse merger is a process in which a private limited company acquires a public limited company and becomes a public limited company. This is reverse merger. Forward merger is whenever the target company is completely absorbed by the buying company and there is no existence of the target company after the acquisition. So asset purchase and the forward merger, those both things requires detailed schedules of IP to ensure that no IP is left behind. Also, asset purchase and forward mergers l- requires triggering of anti-assignment clauses in the license agreements. So we will take all these case things while going through the presentation. Also, if the nature of the buyer is a private equity fund, it is necessary to look into what is the portfolio of company of the private equity buyer, how it operates, what are the jurisdictions it operates, and what are the domains it is invested in. Further, it is in preliminary considerations, it's necessary to identify the nature of the target company's business, whether it's a consumer or a retail brand. Why it is important? Why understanding the nature of business? Because then we can focus on what is the IP that needs to be taken care of in the acquisition process. Suppose if it is a consumer or a retail brand, in that case, the trademarks are the key assets, because the brand is what the intellectual property associated with the brand is the trademark, or the service mark if it is a service provider. If it is an e-commerce website or a healthcare provider or a banking or financial services company, then there is a lot of enforcement related to the personal information, because that personal information of the customers is of prime importance. If it while identifying the target's business, it's also necessary to check whether the target or the seller comes from a regulated industry. What do you mean by regulated industry? Is the industries where government intervention is required for operation of the services. For example, pharmaceuticals or financial services, wherein lot of regulatory approvals are required. Well, it's also necessary to identify whether the research that has been taken place is government funded, or or why it is important, because these things involves the government bodies, and the regulatory approvals are necessary before going forward for the acquisition of IP. Now, it is important in preliminary considerations only, it is necessary to identify the materiality of the IP. Materiality of IP, what I mean by that is, are there current revenues being generated from the products or services that are, so revenues that has been generated from the products or services, whether they are covered by IP or not. So, to give you an example, if a product is protected by a patent, then whether that patent exists, whether the patent has been renewed, you have to check with that, and what is the anticipated revenue that is coming from that product needs to be addressed. Another thing, the patent or the technology may be licensed, maybe in form of a license that has been acquired or license that has been given. So what are the amount of royalties or the license fees that is coming from licensing the IP needs to be taken care of. Also, it is necessary to identify whether there are trade secrets or some patent protection that excludes the competitors from entering the market. It is also necessary to look for the, if there are some specifically available softwares that have been customized for the target company. And also, last but not the least in this materiality is to identify whether the target company has international IP portfolio. Because if the company has international IP portfolio, in that case, it is required that assessing materiality has to be done on jurisdiction specific basis. That is, it has to be done on country by country basis, because laws related to IP are different for different jurisdictions. So while this was all about the preliminary considerations that needs to be taken care of, now we will discuss about the due diligence that needs to be addressed. So the first and the foremost thing is identifying the key people who know about the IP of the target company, because then only you can proceed further on the acquisition path. So, in-house and the outside counsels of the target company needs to be contacted. So, outside counsels will be able to give an idea of schedules of IP registrations and applications or pending litigations also. So if a target company is being sued by some another company, that needs to be taken care of, because that will give a fair idea of what is the future litigation costs that needs to be borne by the buying company. Then it's not also necessary to contact the human resource manager also for identifying the confidentiality and the invention assignment agreements that have taken place with the employees, and how the agreements needs to be enforced. So to give you an idea, every company, when it signs the agreement with its employees, it says the all the IP that will be generated while working as an employee will be the rights of the employer. So this is bit a case for all the companies that that are working in the domain of intellectual property. Also, it's necessary to contact the chief information officer to know about the proprietary software development and software licenses, because they are also important. If a company is specifically using a particular software, then its licenses and the development process needs to be taken care of while acquisition is taking place. Also, it's necessary, if company has market in different international jurisdictions, then it's necessary to involve the local counsel from the relevant jurisdictions to to review the target IP rights. So, what are the different kinds of IP that needs to be taken care of while the acquisition is taking place? Is patents and patent applications. What patent applications are? The applications that have been filed but not granted yet. So, granted patents and the patent applications needs to be addressed while the acquisition is taking place. Further, the trademark, service marks, and certification marks are the key players which identifies the company in the market. So these needs to be taken care of. Other IP assets that needs to be taken care of are internet domain names. What are the domain names that you are using? Twitter handles and hashtags, softwares and databases, copyrights which are registered as well as unregistered, and designs patents. If company is into the manufacturing aspects, then they may have various design patents assigned to them. So if design patents also needs to be considered. If a company is related to semiconductor chip design, then mask works of the chip design needs to be taken care of. So these are the different kinds of IP, which means I'll just repeat the all the IPs which needs to be taken care of: patents, trademarks, domain names, softwares, copyrights, mass works, and designs. So all these things needs to be taken care of while acquisition is taking place. So now, if we take an example of patents or trademarks, it is necessary to know, to verify who is the owner and what is the status of IP. So there are databases which provide the information related to the assignment, whether there are any gaps in the chain of title, which means whether all the fees have been paid up, what is the status, whether the patent is active or it has expired due to non-payment of fees, expiration date of patents which has been that have been assigned. So all these things needs to be taken care of while the acquisition is taking place. So to summarize about the ownership, the main factors are: it is necessary to identify the accuracy of the digital information. If there is any gap in the chain of title, which means that if there are reassignments that have taken place, whether they have been properly addressed in the title registry. Also, whether the security interests have been recorded in the registries in the government departments. What is the status of each item, whether it's patent, trademark, design patent, whether it's uh, expired, live, or under application process. Further, it is also important to know what are the renewal dates of the trademark, or whether the maintenance fees of the trademarks have been paid or not. It's also important to check whether the patents that have been assigned to the target company have paid their maintenance fees on regular intervals. There is a process in which the renewals patent are the legal rights that are assigned for an invention, and those things needs to be properly maintained by paying the renewal fees at particular interval of time. So it is necessary to check whether all the maintenance fee, renewal fees have been paid on time. Further, it is also important to check how the development and acquisition of IP has taken place in the target company. Development, what I mean by development and acquisition, there can be two steps: whether the IP has been developed by in-house or contractors, or whether it has been acquired by buying some patents. So it is necessary to check whether the IP has been developed by the consultants or independent contractors, or whether all the IP has been developed by the employees itself. Also, it is necessary to check whether the invention disclosure, work for hire, and assignment policies have been have taken place in terms of maintaining the compliance requirements. Because if it is being developed by third parties, then the rights inventor is, suppose I'll take an example. Suppose uh, uh, the Nokia, we take an example. Nokia had arrangement wherein Nokia they have launched a program online which is called Invent with Nokia. What does it mean? You give your ideas to Nokia, they will check the feasibilities of the ideas, and if they found it useful for their portfolio, they will develop them in terms of patents. So in that case, the independent consultant who has submitted his idea will be the inventor of the patent, and all the legal rights are assigned to Nokia, because there's an agreement that goes between Nokia and the independent consultant, that the inventor will be the independent consultant, and all the legal rights of developing the IP will be assigned to Nokia. So that agreement goes on. So you have, while acquisition also, you have to understand what are the IP agreements, or how the contracts have been developed during the course of employment, and how the IP has been developed. It is also necessary to identify what was the funding of the IP development, whether it's government, academic institution, research centers. So in that case, the the legal rights are shared between the target company and the funding institution. Furthermore, where other we can look for IP rights is the IP related agreements. There were various types of agreements that a company signs. It may be related to research and development, it may be related to collaboration, it may be related to strategic partnership, joint venture, consulting, co marketing, manufacturing, and intercompany service agreements. So these are the different kinds of uh, agreements that are signed by a company during its operation. So all these agreements should be carefully looked at to identify where the IP is. Because if there are research and development agreements, so it is important that those agreements should be taken care of while acquiring a company, because how the 5 to 7% of companies revenue is put into R&D. So that R&D, in R&D, the company can develop that product in-house or may tie up with other institutions, other companies also. So research and development agreements needs to be perfectly understood to identify where the IP is. Also, there are joint venture agreements. So all those venture agreements must be taken care of when the IP is being assessed. Also, while launching a product, I'll give you an example of patents, how the patents can be assessed. So if you have a patent and you are launching a product, then in that case it is necessary to first perform a freedom to operate study. Freedom, what I mean by freedom to operate, that you're when you're launching a product, you are not infringing on somebody else's IP. To give you an example, take an example of Sony PlayStation. So when Sony PlayStation is launched and Sony wants to perform a freedom to operate study, what does that mean? It means that Sony wants to check it's not infringing on somebody else's patents. So analysis is performed by companies which are in intellectual property domain to ascertain that after the launch of Sony PlayStation, nobody comes to sue Sony for infringing their IP. So if we take an example of Sony PlayStation, in that there is a hardware which has a graphical processing unit, there are software algorithms, there is animation. So there are patents related to all these things: hardware, software, algorithm, and animations, and things like that. So Sony wants to ascertain, Sony will go and perform a freedom to operate study to ascertain that nobody is infringing on these aspects of the product that they are going to launch. So these things needs to be taken care of, and uh, while the products are being launched. Then we'll discuss about the IP related disputes. You might have heard cases related to Nokia and Samsung, wherein Nokia, Samsung, and recently Samsung and Apple. Samsung has sued Apple for infringing their touchscreen, and Apple has sued Samsung also. So these litigations needs to be taken care of, because if your target company is having any litigation, that needs to be addressed, and it should be ascertained where at what level the litigation is, so that can ascertain what is the cost that is being involved in the litigation. So IP related uh, issues, disputes needs to be taken care of while acquisition is taking place. So most important things that needs to be addressed are: what is the nature of the claims, what how the claims are drafted, and what is the scope of those claims, what is the materiality of IP involved, what is the product and the services that gets affected due to the litigation that is taking place, and associated revenue fall if at all that takes place. Also, it is necessary to identify what are the damages and the remedies that have been sought by the companies while litigation is going on. So, all litigation aspects must be addressed carefully before the acquisition is finalized. So, I have given you a glimpse of what are the factors that needs to be taken care of while the acquisition is taking place. So first and the foremost thing is identification of. To summarize, I'll summarize the things in quickly. So first and the foremost thing is you have to identify the nature of the target and the buyer. Then who knows about the IP? What are the IP assets that needs to be taken care of? Who are the owners and what is the status of the IP in the registries of the government departments? Who has developed the IP and how the acquisition of IP has taken place, whether it has taken place by third parties, in-house employers, or third parties, or also it's important to identify whether it's government funded, military funded, or it's funded by some research institutions. Also, I identifying IP titles is not is important, but the agreements that have been signed by the target company are equally important to identify how the IP has grown in the company. And finally, IP protection and enforcement. So you have to take care of how the IP is protected and how it has been enforced. So all these things needs to be taken care of while the acquisition is taking place. So this is all from my side, and I'm ready for the questions if you have.